Good morning, Ms. Grant.
Good morning, Your Honors. Marguerite Grant, Assistant District Attorney for Middlesex County for the Commonwealth, and with me is Adrian Lynch, also an Assistant District Attorney who was the trial prosecutor. In this case, the trial judge abused her discretion in granting a new trial because the defendant took the stand at trial and essentially confessed to a version of events that, as a matter of law, amount to nothing less than manslaughter by excessive use of force in self-defense. He did not have the right to use deadly force, a knife, 5 stab wounds in less than 70 seconds, 4 of them to the victim's torso, 1 to his heart. He did not have the right to use that deadly force in response to punches. And the defendant, when he testified, never said, contrary to the judge's findings and rulings on the motion for new trial, he never said that anybody kicked him in the head. In any event, a kick to the head would be, a boot would be a dangerous weapon, not a deadly.
He was charged with murder, wasn't he?
Yes, he was.
And the jury found manslaughter.
That's correct.
Well, who's to say that the jury might have found him innocent had they known about the violence in the victim's past? Who's to say?
I don't think that the violence in the victim's past, first of all, there is no violence in the victim's past sufficient under adjutant, as I see it.
What was his criminal record?
He had a conviction for possession of Class B with intent to distribute, a conviction for malicious destruction of property, and a continuance without a finding for trespass.
That's it?
That's it.
What about the other participants? In other words, I understand the Commonwealth's position that you look only at the victim, because adjutant, there was a victim. Here we have at least 2 participants, active participants. In other words, he is confronting 2 attackers, correct?
According to his version of events, but even according to his...
I thought even according to Mr. Rodriguez, he participated in the attack.
He got out of the car. It took him some time to get out of the car. He went around the car, and he responded in defense of another and punched the defendant once in the head, dropping the defendant, pulling him down by his rain slicker, dropped him to the ground.
Yeah, but you've got 2 attackers. It's not as if he's some bystander across the street, because there were some bystanders, correct?
That's correct.
Isn't there sufficient evidence that the 2 people in the car were acting, if you will, as joint venturers?
Of each other.
Yes.
In defense of each other, yes.
And if that's the case,
Well, how could
then
he
wouldn't
act-
the evidence that should be admissible against one be also admissible against the other?
Here, well, that brings me to the discovery issue. Unlike an adjutant, this defendant never filed a motion to eliminate to get in the prior bad acts of any of these witnesses.
So you're saying because it's a common law rule and there's no retroactivity that's involved here, he hasn't preserved the issue for purposes of this appeal?
That's correct. That's
How
one.
can you say he hasn't preserved the issue, though, when he objected so many times and went to sidebar a number of times to try to get in the very evidence that we're discussing now?
Well, as to one of the times he objected, the judge overruled the objection, but her findings and rulings claimed she sustained the objection.
No, I understand that. I mean, in other words, the focus here is what happened at trial. And, I mean, there's no question that, as I understand it, and I haven't read the trial transcript, what defense counsel was trying to do was find a space, as it were, between getting this evidence in as much as he possibly could. And as the trial judge recognized, she was, because adjutant hadn't been decided, making sure that if the defendant didn't know about the prior history of the attackers, it was not coming in on those grounds.
Correct, which is why the trial prosecutor filed a motion to eliminate to preclude prior bad act evidence until such time as the defense laid a foundation. And the defense never did lay that foundation. In fact, in response to the prosecutor's motion to eliminate, defense counsel repeatedly said, "Oh, Your Honor, we understand the propensity law in Massachusetts."
That was the rule at the time.
Correct. But they, as a result of the fact that it was the rule at the time, they didn't file their own motion in limine, and in response to the prosecutor's motion in limine, they conceded that they weren't going to offer it. And then when it came to trial, at the various points where the defense claims they did offer it, either the judge overruled the objection and now claims she sustained it, or conversely, the situations, the examples of the evidence the defense was trying to proffer were reputation evidence.
Yeah, that's a separate question, and I'm planning to ask the defense, what exactly are you aware of any specific acts of violence and not general reputation evidence? I would consider that he was a street fighter is general reputation evidence that adjutant prohibits, not specific acts of violence. And were there any specific acts of violence that they offered during the trial?
No, and in fact, at volume transcript September 21st, 2004, page 195, when this issue came up, the prosecutor was virtually prescient of adjutant when the defense was trying to get in evidence that the victim tended to make comments to people and cause trouble. The prosecutor said, Your Honor, there's no specific incidents in question. It's characterizations. This is prior bad acts for propensity purposes. So she somehow saw it coming.
What if we were to try to...
I'm sorry, go ahead.
What if we were to remand this to the trial judge? Because it seems to me that the evidence she indicated should have come in was general reputation evidence or just general character evidence for a hearing on whether there are specific acts of violence that should have been admitted and that, if had been admitted, might have changed the outcome of the trial.
Well, that's certainly one of the things you could do. The trial judge repeatedly insisted at the various hearings on the motion for new trial, I'm not going to hold any mini-trials here, and I'm not even going to rule on the admissibility of this evidence.
Well, but I think that adjutant results, perhaps, in some mini-trials to make a threshold determination as to whether evidence is admissible.
Ms. Clant, let me just ask you this, if I can. In her memorandum and decision allowing the motion for a new trial, talking about the victim first, she says that there were the arrest, the evidence that the jury would have heard, I assume, for the malicious destruction, which was an incident in a restaurant. He threw money in the face of the cashier on duty's face, kicked the front door, shattering the glass. At the time when he was arrested, he was belligerent with police officers. He threatened to have his Lions boys take the police out. There was also evidence proffered, including a letter written from the victim's mother concerning use of alcohol and its influence on his conduct. That's with the victim. Then, with respect to the other participant, he punched his former girlfriend in the face, throwing eggs at a vehicle, attacking a motorist who stopped at the time that he was arrested for not carrying a firearm. He attempted to pull the loaded gun from his waistband before being attacked. When he had an argument with his mother, he slammed a cup in his sister's face, leaving her face swollen and puffy. I mean, it seems to me that that's precisely the evidence that adjutant is directed to. It's not a general reputation. It is very specific conduct of two participants in a confrontation.
Well, let me respond first to the part you said about the victim's evidence. The letter from his mother about her, to his probation officer, which is at RA 488, about her opinion that he had a problem with alcohol, that's hearsay. It's opinion. How is that going to come in?
I would say that's general character evidence, but what about this, that he threw the whatever it was at the door and did whatever he did to the waitress?
And for that, he was convicted of malicious destruction of property. Okay. So what we know from that is when he's angry, when he's confronted by somebody, he destroys property.
Well, it doesn't have to be the same just because he was convicted of malicious destruction of property.
But
he reacted to something in a violent manner.
And he wasn't even accused of touching the clerk. And besides which, where is Marcos Pinero? Marcos Pinero is the guy in the pizza place. He wasn't even on the defense witness list. Where is he? Do we know where he is today? Did they proffer an affidavit of him?
But
That's
Ms.
another
Grant, it
issue.
seems to me that you're going off in tangents. I mean, the question here is should there be a new trial in light of adjutant, and then presumably the defendant will put on whatever evidence the defendant has?
But part of the problem is
With the judge limiting it very specifically to specific prior bad acts of violence and not A great deal of what she discussed, I think, was general reputation or general character, but some of it was specific acts.
But did the defendant actually make an offer of proof as to specific acts?
No, he kept trying to get in these characterizations that and he did get some of them in, that the victim was always on his toes. He tried to get in that the victim and Sammy Rodriguez grew up fighting. And he got some of that in about the victim. He had police officers on the stand who had responded to some of the victim's past incidents, and he didn't question them about this. So it's not like Adjutant, where the neighbors were actually on the stand and the defense tried to get it in, or an Adjutant where the defense filed the motion in limine. This was a situation where they insisted, they refused to give any pretrial discovery about prior bad acts, insisting that the due process clause meant that they didn't have to give any discovery, which we now know under Durham is just not right. They tried to conduct trial by ambush. And the trial judge essentially rewarded them for that, saying, well, I'm not going to revisit the discovery rulings that Judge Bone made in August of 2004. But the trial judge essentially rewarded them for the trial by ambush by essentially saying, well, we don't know what it is, but there's something out there.
That may be one way to characterize it. Was Durham decided before or after the discovery rulings?
Excuse me?
Was Durham decided before or after the discovery?
I think Durham was decided after the discovery rulings,
well,
as was Adjutant.
To say that she's rewarded him, it seems to me that what the trial judge was doing, the trial judge, it struck me in a somewhat unusual posture. I mean, within days of Adjutant being decided. In other words, the trial judge knew, it seems to me, precisely what the defendant had attempted to establish at the trial, and that she had let me just finish. That's the way it strikes me, what he had attempted to establish, and it strikes me she read Adjutant and thought all of this evidence could have made a difference to this jury.
I don't know that the trial judge knew precisely what the defendant was trying to establish at the point she ruled on the motion for new trial, because she didn't have the transcript of the defendant's testimony.
That is correct, and so so one can't falter. This is a trial judge who I suspect is trying to move things as fast as she can. She doesn't have a trial transcript. She knows that this is evidence that, at least she is of the view that this is evidence that, had it been introduced to the jury, could have made a difference. That seems to me the basis of her ruling, and to say that she is rewarding somebody, I think, is really not what's at issue here.
I don't see how it could have made a difference if the set of facts that the defendant testified to as a matter of law amounts to nothing less than manslaughter by excessive use of force and self-defense. It's possible that had the jury heard these prior violent acts, that they might have thought, ooh, the victim sounds like a bad person. Ooh, his cousin Sammy Rodriguez sounds like a bad person. And if they're joint venturers, we should attribute Sammy Rodriguez's bad acts to the victim.
No, they might have thought that these are two young men who have a history of being involved in confrontations such that when the defendant says they, I think the word was exploded, or one of them exploded out of the car and came at me and the other one followed straight, that's the point at which the jury might have had a difference.
The Commonwealth didn't dispute. There was no dispute that the victim threw the first punch. That's the problem. There was a dispute as to whether or not the defendant touched the car door. There was a dispute as to whether or not the defendant had his knife.
Trying to argue that he already had the knife out.
Right. The Commonwealth argued that inference. And if the defendant had been convicted of murder or deliberate premeditated first-degree murder, then I might have a much more serious problem here. But here the jury rejected the self-defense argument on proper instructions from the judge, and they also rejected the theory that he premeditated this murder.
Wasn't Adjutant a self-defense case?
Yes, it was.
Right?
Yes.
And what we know is that as juries are weighing up evidence, they might not have thought he had a knife, because as I recall, and again I haven't read the transcript, Rodriguez couldn't testify that he'd seen the knife.
The defendant admitted he had a knife. He admitted he used it.
That he hadn't seen the knife, Rodriguez, hadn't seen the knife when he approached the defendant. But the jury could well have concluded that it was really the defendant who was being provocative and essentially saying, come on, which may have made a difference.
Either way, whatever prior acts of violence either the victim or Rodriguez had, don't shed any light on whether or not the defendant opened the car door.
But you're
They shed light on the claim is that this, by the defendant, that this was a ferocious attack upon him by two people and he was outnumbered. And the specifics of who opens the car door don't really change the dynamic of his version of being down on the ground and they were pummeling him and he was worried about his head. And
Assuming they're pummeling him and he's down on the ground, that doesn't give him the right to use deadly force.
Why is that?
Because it had to have taken, by the defendant's own testimony, it had to have taken some amount of time for for the second assailant to get around the car, during which, under the Harrington prongs, he had an opportunity to flee. And under
He had an opportunity. No, wait a second. His testimony is that he's on the ground.
Right.
On the ground.
But
someone is on top of him,
there's a
pummeling
line-
him. A second person joins in. Exactly how is one
there's a line of cases, including Ramos, Barros, Alves, cited in my brief, that stand for the propositions that it doesn't matter if the victim threw the first punch, it doesn't matter under Barros if the defendant has a history of having been shot and stabbed and beaten before, and it does, under Alves, at some point, on a public street, unlike an adjutant, on a public street, the defendant at some point has the opportunity to flee, but most importantly, the third prong of Harrington under Reed is that using a knife in response to non-deadly force.
How is he supposed to know that this is all about non-deadly force? Just assume the worst for a moment. Someone has exploded out of the car. You're on the ground. You're being punched. A second person is joining in, perhaps using their feet to try to kick him in the head. And he's supposed to say, okay, I don't think there's a weapon up there.
He
I'm not
didn't
sure.
testify that anyone used their feet. And he did testify that he had the chance to take his knife out and hold it up and see it gleaming and plunge it 5 times into the victim's body.
But that's different from an opportunity to
Was
run
to
away.
flee, yeah.
Well, that's
Running away would take getting up off the ground.
Okay.
Getting away
But
from the
that's
individuals.
running away is the second prong of Harrington, along with other means to avoid combat. I have a knife, I'm going to use it. The third prong of Harrington is...
So he's down on the ground. I have a knife. I'm going to use it. I
Right.
mean, this is what this is a predicate
Look
for
at-
defending yourself in this
Look at
manner.
what Sammy Rodriguez did when he saw the defendant with the knife. Hey, man, I come in peace. Sammy Rodriguez instinctively understood
Was
the
Sammy
law.
I'm sorry. Was he on the ground? Was someone on top of him when that
No,
happened?
but what I'm saying is the defendant is expected to react, to respond in a way that's consistent with the law of self-defense of this Commonwealth. The fact that he may not have known the holdings of the various cases, the law as applied to these defendants like Ramos and Barros should also apply to a defendant with the name Pring-Wilson. And
That's got nothing to do with it, quite frankly. The question is whether someone, and we've got to sort of take his version right now at the moment, that's what we're considering, who is attacked by two people after an exchange of words, explosively attacked by two people, is down on the ground, is fearing for his own safety, is being pummeled by two people, somehow, before he can use anything other than his fist to defend himself, must break free from this, declare that he has a knife, and only at that point can he defend himself with that knife.
Well, that's the 3 Harrington prongs taken together say he has to have a reasonable fear of death or imminent serious bodily injury. I say he doesn't, from pummeling.
From pummeling, two people
Justice
pummeling one on the ground.
Second.
Okay, that's your
Second,
view is that's not a
fine.
reasonable fear.
Second, he has to use all reasonable means to avoid combat. Reasonable means could...
Combat is there. He is in the middle of
It's there
combat.
once the second assailant gets out of the
In a
car.
few
There's
seconds.
some period of time when he could have avoided the combat. But most importantly, no more force than is reasonably necessary. 5 stab wounds.
And how was he to
Less
know?
than-
How was he to know in the seconds or minute and a half that this transpired, where he is on the ground? I'm taking his testimony now as I understand it. He is on the ground. How is he supposed to know that they're not armed? Is he supposed to wait for the first knife wait for the first, what is he supposed to do in those, what is a person supposed to do in those circumstances?
Those other cases, the other cases where the court has repeatedly said in Walker and Reed that the defendant isn't supposed to use deadly force in response to non-deadly force, none of them say, but if he thinks they have a weapon. In fact, it was...
If he's on the ground and they're on top of him and he has perhaps no other way to escape other to use. This is what we're not talking about people that are apart from each other. We're talking about people that are in combat, one on the ground, 2-on-1.
I would say
right?
look at Commonwealth v. Barros, cited in the Commonwealth's brief. And I don't think the court wants to make a rule that says if a defendant thinks they have a weapon, though he doesn't testify that he saw one, then the fact that they might have had a weapon is enough reason for him to use deadly force in self-defense.
Certainly not standing apart, of course not. That's not what we're talking about here. I think they have a weapon. I saw them come out of the car. I thought they had a weapon. That's not what we're talking about here. We're talking about someone being on the ground, being, according to him, pummeled by two people while he's on the ground. That's the context in which this occurs.
That's correct. In any event, I see my time is well up, and I would ask the court to reinstate the conviction for the killing of Michael Danielle Colono.
Thank you, Ms. Grant. Mr. Lankin?
May it please the court. Judge Quinlan was the trial judge in this case. She was the trial judge, by coincidence, in the adjutant case. She clearly recognized the significance of adjutant to this case, which had been tried several months after adjutant. The decision in adjutant came down several months after the trial of this case. Under Rule 25b-2, she has very broad discretion to set aside a verdict, as she did in this case, if she feels that the result is not consonant
Mr.
with
Rankin,
justice.
excuse me, let me ask you the question that I indicated I would ask. What are the specific prior acts of violence that you would offer or would have offered at this trial? I know about the one of the throwing something at the glass in the restaurant, and I bear in mind that I do not consider that he was a street fighter. To me, that's general reputation and character evidence. So what specific acts besides the one in the restaurant would you have offered had you been permitted? Or
There are two with respect to Michael Colono,
Yeah.
The victim. One is the incident in the restaurant where he has an altercation with a dispute with the cashier, throws money at the cashier, breaks the door, and is loud and disorderly, uncooperative with the police.
Well, loud and disorderly is not a specific act of violence, but
That's one incident.
Okay, what else? Yeah.
The second incident is when he was arrested for trespassing at a housing project and makes threats to the police officers. That is consistent with the kind of threats, kind of evidence that this court in adjutant noted, threatening behavior.
So those are two acts in regard to Colonna, and what,
Yes.
if any, in regard to Rodriguez?
Rodriguez has a plethora of acts. In one instance, the police had a tip that he had a firearm. The police approach him. He flees, pulling the firearm out of his waistband, and is tackled, and the firearm tumbles to the ground. In another incident, he and a group of other kids are throwing things at passersby in cars. A car stops to see what hit him. They take Rodriguez and his friends take a bicycle and break the windows of the car. In another incident, Mr. Colono assaulted his sister and his mother in a domestic violence sort of case. And in another incident, he pulled a knife on his
Is this Rodriguez?
Yes, Your Honor.
Okay, because you said the other guy.
You just said Colonna attacked his...
I apologize. These are set out quite briefly in pages 19 to 25, 24 of our brief.
Okay, they're on pages 19 to 24. Do you agree, is it crystal clear that general reputation evidence cannot come in? I mean, it seems to me it would be highly relevant if, in one of these types of incidents, there is evidence that someone is, quick-tempered, quick to violence, quick to fight, will pick a fight with anybody, that kind of stuff.
I mean, this is an issue that the court debated at some length in adjutant.
And apparently it's off the table.
And
Well, it was off the...
Well, if the defendant knows about it, If the defendant knows about the reputation, it's admissible.
That's true. That's been true long before Adjutant. Adjutant said, we're going to let in specific acts of violence, but for the time being, as we embark on this new part of our evidence law, we're not going to let in the reputation.
Can I ask you, what is the state of the evidence with regard to, there was something about somebody doing a lot of fighting as a youngster. And it seems to me if these are incidents that are observed but only remembered in a general way, i.e., I saw him fight with his brother many times, it seems to me that is still, it's not a specific incident, but it's not reputation. It's something that the person observed, or at least it could be. If it is testified to as, I saw him fight numerous times, so many that I can't pick out a single one, but I saw lots of this.
And I think
that's
Your
not
Honor,
reputation, it would seem to me.
I agree. And I think Your Honor's question to me just now and to Ms. Grant earlier reflects somewhat the reality of this trial. I mean, from before the beginning of the trial, it was clear that the defendant had done a tremendous amount of investigation of Colono and Rodriguez and knew about a number of incidents. Ms. Lynch's motion in limine before trial identified all the different incidents that we're talking about and 40-some witnesses that were either police officers that investigated them, victims of their different crimes, or witnesses as potential defense witnesses. And at the in limine hearing, as Your Honor suggested, they were trying to figure out how the defense could use this at trial and not entrench on what was the law at the time, that unless it was known to defendant, it doesn't come in as propensity evidence.
I assume you were aware at trial that the Adjutant case had been argued.
I wasn't trial counsel, but certainly trial counsel was well aware of the issue of the fact that Massachusetts was alone among most of the jurisdictions in American jurisprudence not permitting this sort of evidence.
I mean, because he did about everything he could do to get this evidence in.
Yeah, I mean, it's traced through very precisely in our brief. And, you know, I think Judge Quinlan's decision says it wasn't fair for Ms. Adjutant, and if it wasn't fair for her, according to this Court's decision, then it's not fair for Pring-Wilson.
Well, she says that, but she says that if the defendant can claim the benefit of Adjutant, in other words, if Adjutant applies to that case, a new trial is necessary. If it doesn't, it's not.
And this presents an issue that has been a thorn in the side of the Supreme Court and of this Court. You have two similarly situated individuals. One gets the benefit of the rule. What do you do with the other person?
Well, she actually, it's like, I mean, I don't wish to contradict Justice Cordy, but she's going through very carefully to say, I understand it's a common law rule, it's not a constitutional rule. This case, the record hasn't been assembled, it's not up on appeal, it's still here. I'm very aware of what defense counsel, I mean, it's a very strong statement that she made, which is the issue is not frivolous, preserve the issue which is for appeal, which is being perfected. And it seems to me that she is in essence saying whether or not Adjutant applies in only for cases that were tried after in these unusual circumstances under Rule 25, I am exercising my discretion. That's how I read her.
Which is perfectly all right. It seems to me, apropos of what we're talking about, you don't have to get all snarled up in the retroactivity or not issue. The judge, under Rule 25, had to make a decision whether justice wasn't done. That's the standard, which, as you pointed out, is highly discretionary. And that's what she found. Justice wasn't done. So, assuming everything else checks out, that's the end of that. Forget about retroactivity.
I mean, it's an issue that Justice Quinlan, immediately perceived once Adjutant was decided, and it was decided at a stage when it was still in the trial session. The appeal had not been assembled. The record hadn't been assembled and perfected. It was not a situation where not even a situation where the case was pending in the appellate court and the defendant was seeking to have this law applied as if it were a constitutional rule where normally it would apply to a case from direct appeal.
I have a
It
question
seems
on
to me that apart from anything else, what she has in essence said in her conclusion, that apart from the waiver or anything else, is that in her view, Massachusetts was out of line with most of the states. We joined the majority because we thought it was important to the truth-finding function of the jury. That's what it seemed to me Justice Quinlan was hanging her hat on, saying, I think the truth-finding function was impaired in this case because she was carefully following the requirements of the law at the time.
I mean, it's very different from a case where you're saying, well, if the police don't tape record or explain why they don't tape record a statement, we're going to let the trial judge give an instruction upon request, where you're regulating conduct of law enforcement officers, or the 6-hour rule. And it's even very different than the cases where you're saying, we believe that in the future the judge should individually voir dire potential jurors on child sex abuse cases. This is a matter, as you say, that really does go to the heart of the truth-determining function. I mean, if the court is correct that jurors would find it helpful to know that one of the participants in a brawl had engaged in numerous prior acts of violence.
But why does that matter in this case, where the scenario, I take it, the scenario of the events that took place, where the defendant in this case was beset by two people, isn't that all the jury needs to know? Isn't that the essence of the truth in this case?
Well, I think that Ms. Grant...
I mean, otherwise it comes down to a trial of a victim based on what their past is. He had it coming.
It's not, that's not the focus of the defense presentation. The defense contended that the prosecutor was wrong when she said in opening that the defendant was the aggressor because he opened the car door, thereby invading their space. He had his knife at the ready. Over and over again, from the beginning of this case, its initial statement of the case, through closing argument, the act of opening the door attributed to the defendant by the prosecutor was the act of aggression. The defendant denied that he touched the car. So the question of who was the aggressor and does it make sense that the defendant would do that, or is it more likely that these two men would jump out of the car and set upon the defendant?
Don't you have to frame the problem from the eyes of the defendant's evidence? Isn't this almost like a corollary to the rule that the judge has to instruct on a defense issue when virtually any version of the evidence will permit it? Don't you have to look at it from the defense version?
Well, on the question of entitlement to a self-defense instruction, certainly.
No, I'm not talking about that. I'm talking about gauging this, whether this evidence would be helpful to his defense.
Well, you have to gauge it also in all of the circumstances because the Commonwealth's theory is that he's the aggressor. I mean,
Well, right. So you disregard that and you take his theory, which is he wasn't the aggressor and they were, he's worried about deadly force and all that kind of stuff was 2-to-1, so forth.
Right.
And you say, well, now we got to examine this problem from that viewpoint. Am I right?
Yes.
Okay.
I have a question on a different subject. What is the evidence that Lewis's statement is against his penal interest?
Lewis...
I know what he did and I know what it says, but how was it against his penal interest to make that statement?
Well, he would be admitting to participating in, to lying to the police about the presence of Rodriguez when they were looking for him after he assaulted his girlfriend. The police came to his door and he lied about it. He would be...
Is that a crime? I know that making a false police report is a crime, but I suppose that would be obstruction of justice.
I think that's fair.
That's,
and I think that the The reason I think the judge said that he had a valid Fifth Amendment privilege is the suggestion that he would have been partaking in the drug use.
No, but I don't see that in his affidavit. That's why I'm asking you. I understand why she made her ruling, but I don't understand why you argue. And I understand your argument that it's contrary to her ruling, but I still want to know, he's saying that the other two were taking cocaine and he witnessed them taking cocaine and all that, but as far as I know, just being present when somebody else is taking cocaine is not a crime.
That in and of itself, I agree.
So how is that statement against his penal interest?
Well, I think that the penal interest part of it has to go to his lying to the police about the presence.
That's the most?
Yes.
Okay.
Finally, I have 40 seconds. I think there is a serious problem with the Commonwealth's right to be here at all in this case. We filed a motion to dismiss the appeal.
Didn't you waive that?
I'm sorry?
Didn't you waive that, Mr. Lankin?
How did we waive that?
Didn't you first respond and then file a...
We filed our motion to dismiss the appeal when our brief was due as
maybe
well.
I got the timing wrong.
But if we view this, why shouldn't we view this either, as Justice Graney said, or as a motion under Rule 30?
Well, because
which
it's
our
not
cases have done in the past.
Well, I think the cases have taken what's been filed as a Rule 30 and said, no, this is properly a trial motion. We're going to treat it as a 25B2 motion. I don't think the Court's gone the other way. I just raised that because I think that the Court needs to address it for this case, certainly, and for future cases.
Thank you, Mr. Lankin.
Thank you, Your Honors.